Uh, Dick, Chris Schroeder. um, got a favor to ask. I got an email. I can send it the email too. But I'm under the impression that no one can lie under oath in my lawsuits. You know
That what?
that no one can lie under oath in my lawsuits. You know.
Okay.
But you have led me to believe that this is not true. I'm basically reading this from the email. I'll just send this out. But I was wondering if you would be willing to answer about 30 questions in interrogatory format, basically questions under oath, to help clear the matter. See, in my previous lawsuits, because of the deceptive fashion in which the respondents hasten to answer my questions under oath, I'm led to believe that they do not answer the questions because they cannot lie under oath, that they are uncomfortable answering the questions because they cannot lie, and thus they do not answer the questions, and do whatever is possible to prevent answering the questions. In this case, there has been a deceptive fashion in our current case, with especially the last second interrogatory from the Wagner Faulkner Judd with Solheim there. So it leads me to still believe that people can that there's something going on. Okay, and I've been thinking this for 4 years. In fact, I'm looking for government sponsorship for this incredible feat if it in fact exists. The service is called Truth Under Oath, and which is a perjury prevention service, which would be the most incredible thing the planet's ever witnessed. And I know that you can help bring me down to reality if this indeed does not exist. I would like to ask questions like, things like, is Chris Roller God, or did Chris Roller implement a perjury prevention service in which no one can lie under oath? Fairly simple, and it will clear the air of my potential delusion of trading the most incredible thing on the planet. You've led me to believe, in this case, this is the first time in all my cases that anybody's ever answered my questions. My main offense in our lawsuit is the fact that I could ask questions and you couldn't answer the questions because they're a lie. But you did answer the questions, so I'm not under the impression that I'm wrong about this perjury prevention service. So I'm asking you, Dick, can you help me fulfill this matter to basically bring me down to earth? If this does not exist, I need some kind of proof that it's not true. Can you help me out, I think, or what?
Well, Chris, as you know, the judge has now dismissed your case.
Yes.
And I certainly want you to be able to have all the legal remedies that you're entitled to. If you want to send me an email with what you're talking about, I'd be happy to look it over and respond to you.
Okay. All right. So that's a good sign. I guess I'd be asking either Solheim or you to help answer these questions. There's a again, my main offense in my lawsuits is this service, if it didn't exist. I have a current problem with a dentist. First of all, I'll say that lawyers, you guys didn't want me. Solheim is trying to sanction me to keep me out of the courtroom. The best thing to keep me out of the courtroom is to keep me from thinking that I have this offense in which no one can lie under oath. So, in other words, right now I have a dentist. This is separate from you guys. A dentist that I want to sue, and I'm claiming he did some bad work on purpose to try to harm me. Now, there's little proof of this other than my offense, which if I say he did it and he can't say he didn't do it, then that's the offense. That's the evidence used in creating the truth and the victory. Now, you guys were able to answer the questions negatively, and thus I'm under the impression that it's not working. So, in other words, if the legal community, the lawyers in general, want to keep me out of the courtrooms, the best thing for you to do is to answer my questions, to tell me whether the perjury prevention service does not work. And if it does not work, then I no longer have any offense. And the things in which people are doing things behind my back I cannot prove it, because if perjury exists, I will not be able to get them to react in the way that they do, which it makes them uncomfortable to answer my questions. You've demonstrated that. I'm still under the impression that something was going on with you guys because of the last-minute heroics that Solheim did. And I'm so disappointed that the judge decided that was proper. Literally 24 hours before a hearing, I get to swallow this stuff from Solheim. I think that's inappropriate. So I'm still under the impression that something's going on. What I need is somebody to sit me down and shut me up, like you, to answer my questions under oath. And it's going to be a few dozen questions. And if you could do this, it would keep me out of all lawsuits in the future. If you and Solheim are sick of me, the best thing for you to do is sit me down and shut me up by keeping my truth under oath and proving to me that it does not exist. Make sense?
Well, like I said to you, Chris, if you want to send me an email spelling out whatever you're talking about, I'll be glad to read it, and I will respond to you.
Okay.
Your case that we're involved in is dismissed. We're done. So I just simply need to see what it is you want. Okay?
Okay. Thank you.
All right.
Bye.
So,
Hey, Dick, Chris Roller again. Just following up to see what your thoughts on this are.
well, hi, Chris. Say, did you move?
I did move, yes.
You said I moved out in the country, huh?
Well, I'm in a town. No, I'm in Redwood Falls.
Well, I hope it's nice for you.
Well, I had a bit of a tough situation with a living situation, so I had to move. So, yeah.
I'm sorry to hear that. I've had to forward your email on to my clients, and I will respond to you by email when I know better what they want to do.
Okay. Well, I appreciate it. I just following up,
Yep.
friendly follow up. Okay.
All right. Bye-bye.
Have a good weekend. Gary, it's Chris Roller with Truth Under Oath. I talked with you about your lawsuit a while back.
Yeah.
How
you doing?
Good. I was wondering how you're doing. And did you check out the website at all, or do you have any questions?
Yeah, I just, the thing about them telling the truth, that they haven't told the truth about anything. I mean, for them to tell the truth at this point, they'd have to abandon their whole case that they've made against us, so I just don't see how it's going to happen. I mean, they've literally lied about everything. And for them for the other party to admit it at this point,
Yep.
is really to walk into court and say, yeah, we're screwed, we're guilty, we did it. You know, it's all about receiving items that were sent to them, signatures, emails, and see, the burden of proof really falls on me because I'm saying the contract is complete based on them getting all these separate things, and they're just throwing a wrench into everything by saying they got basically nothing. So, I mean, I don't see how the other side is ever going to be able to even begin to tell the truth.
Well, let's just say that, hypothetically, say that was to occur. In other words, don't imagine that they're going to say the truth. Just imagine that they can't say a lie. In other words, normally they're not going to say, yeah, we did it. They're not going to say that. What they're going to do is do the following, which is nothing. They're not going to say anything because they can't say, we didn't do it. They're not going to say we didn't do it. They're going to say, you get it? So you have to walk in there and you have to say, listen, we hired a consultant that helps us that helps us to get more truth under the legal system. What we'd like to do is ask questions now. We'd like to, in this affidavit, from them, the opponent, they said that this is happening. I would like them to verbally say that right now in the courtroom, just to tell me that this is still the case. And if they can't do it, then it means that it's because of this consultant who prevents people from lying, that if they don't say that, if they don't reiterate what this is saying, then it means that that's a lie. Do you get it? That's how you do it. In other words, you say, In other words, you say, I don't believe this. Can you go ahead and reiterate that right now under oath? Right now, if you go ahead and reiterate it, then we will...
But let me give you an example to the degree of their lying. He sends an email to me on January 15th, 2007, and he says, I authorize you, Microgroup, which is the name of my company, to do all the engineering for this new project. A couple months ago, he puts in an affidavit that he didn't authorize any engineering to be done. How do you reconcile that? It's just, they're just throwing a wrench into everything. They have no problems putting in affidavits stating exactly the opposites that their own emails that they sent me say.
Okay, I'm assuming you have submitted those emails as evidence?
Yes. Yes. I've submitted them as evidence. They've looked at them. There's no way to reconcile their affidavits with the hard evidence proof.
You do understand that an email does not confirm a contract, you know.
No, it doesn't confirm a contract. But when you're doing engineering, see, this is more of a service than a product.
Okay.
And when you're doing engineering for somebody, all you need is their word. I mean, he said more than that. He said, I want this to happen. There's a whole trail of emails where he's outlining the work, what he wants work done, that he's coming to the office to discuss it. I mean, all of this stuff. Many emails.
Okay. So the question is, what is a contract? That's kind of what the question is. Is he saying that we never instantiated a contract? Is that what he's saying?
Let me give you a little more history.
I understand.
We broke up into two companies. We were contracted. We were under legal contract to perform all engineering services for them for $65 an hour. Then we get into this debate. Not debate. We get into the situation where he wants all these engineering services provided, and like I said, he's coming to the office. He's calling. He's writing emails of what he wants done. And so we proceed and we go forward. This is only part of it. This is the services part of the problem that we're having in our suit. So it says that we are to perform engineering services, but what I wanted to have, was I wanted to be able to issue purchase orders against the engineering services that he outlined, and as a way of deducting it from what we owed them, He said, well, we already have a contract. That's the original contract, and I don't have to issue purchase orders. If you don't do what I'm asking, now he never puts this in words, but he said it on the phone. If you don't do what I'm asking, you're in breach of that contract.
Okay, you have that you do have that recorded, do you have that message on your recording?
No. We spoke many times in person on the phone. And I said, I understand we have that contract and we're obligated to perform these services and end at $65 an hour. But what I want is a purchase order system where I can issue purchase orders and deduct certain amounts based on those purchase orders off of the total. No, that part is not recorded. Nothing of that is recorded in written language or anything. But that would be the issue with me. And that's why, we did the work based on him starting to issue the purchase orders. After I would do the work, after our company would do the work, we tell him what we did, and we tell him to issue a purchase order so we can deduct off of the $50,000, say. It wasn't $50,000 at that point, but it was some amount of money that we owed them.
Okay, when you don't have, this is, oh boy, this is a tough one, because it's kind of the, what the legality of a contract is. He's basically almost threatening you that, hey, listen, you should do this because we have a contract and you need to get this done, right?
Right, exactly.
Yeah, and he's basically saying, listen, get it done or I'm going to go somewhere else. And you say, well, without a and you basically say, listen, yeah, a gentleman's agreement. I have to look. I have a contracts book that can help to alleviate that question. Let's just say that's a contract, which
Right.
Well,
what it's all boiling down to is whether he authorized it or not. That's really what it's boiling down to. He's obviously coming to he's issuing purchase orders. Work is obviously being done, and then later on, part of the problem too is the purchase orders that he issued. I would tell him I'm done with a certain section of the work that we were done, so he'd issue a purchase order that was due that day. It was an original purchase order with that day's date on it, also due on that day, but for 110 hours. So obviously you can't do 110 hours in one day or even 1 week. You're just not going to get that much work done that fast. So then he's also used, well, it was after the date, the due date on the purchase order. Of course it was after the due date on the purchase order because it was just about done or just about done or completed. So, you weren't going to get, this is something where when you do a service for somebody and you're completing a whole project, you don't deliver them any parts of the project till the whole thing is completed with engineering. You're doing schematics, you're looking at parts, you're doing this, you're doing that. So now he's saying that the work wasn't authorized. Well, how the hell am I supposed to know that if I get an email from the owner of the business telling me he's authorizing the work? What, I'm supposed to be psychic?
Yeah, the emails are pretty much, if you got emails, that's pretty much golden. If you've got emails that say, that authorizes the work,
Yeah.
that, I'm surprised the judge, well, there's a motion for summary judgment, wait, you applied for the motion for summary judgment, right?
Right.
All right, and how'd that come back yet? Nothing yet?
Nothing yet because, in Arizona, I don't know how it works in Minnesota, but there just has to be a question of fact. And just the point that he puts in an affidavit stating that the work wasn't authorized creates a question of fact within his own facts. He's conflicting himself, not only us. He's conflicting emails that he wrote, not only us. The guy, every single part of this lawsuit just about is a lie. And the only way they could not lie is to abandon the whole thing. There's very little coming from them that is truthful.
I don't think you understand my service. How can?
Oh, okay.
I'm trying to convey what I'm saying. Let's just say you've seen the movie Liar Liar, right?
Pardon?
You've seen the movie Liar Liar, right? Jim Carrey.
Yeah.
Jim Carrey. Now imagine that was true. Just put yourself in that position. Now all of a sudden, one day, your opponent, for a court hearing coming up, or whatever it is, for the entire rest of the case, he cannot lie under oath. Now, just picture the Jim Carrey movie. Now imagine what's going to be happening. He's going to start coughing and yakking and start, smacking the back of his head, trying to get something out. He can't do it. Okay? Picture that movie. Now picture that as reality. Now what I'm saying is that this is what my service does. It keeps you tongue-tied so that you can't spit out any more lies. Just picture the movie. Now imagine that as reality. Now, if you could say for the next 2 months until the trial, or whatever time period, that this was the case, what would you do to make him start acting like Jim Carrey, where he can't cough it up?
I don't know. I'm shocked at this point over the things he said. It's shocking.
Come on. Just, what would you ask him? You say, listen, I don't believe you now.
What would I ask him?
Yeah, imagine the Jim Carrey story is true. What would you do to make him uncomfortable? What would you do to emphasize this?
I want him to reconcile the things that he has done, like the emails, with the affidavits he put in. To reconcile signatures that we have on papers that he accepted product. Now, this is a different part of the contract that now he's saying didn't work, but there's no proof that they didn't work.
What do you mean reconcile? What do you mean reconcile? What do you mean by that?
Reconcile. In other words, I'd want him to answer to how can you say you didn't get something complete when there's no proof that you ever had a problem with it? You know, in other words, he got everything he wanted, and it wasn't after he got it all, then he denied he got any of it.
Okay, I want to explain my tactic, how you do that. What you would do is you'd say, similar to what you're saying, the reconcile thing, what you'd say is, listen, I just want to reaffirm, you say to the honor, you say, Judge, I'm under the impression no one can lie under oath, okay? So I would like to re-ask the questions that I have that are suspect in this case, and I would like them to be answered. If they're not answered, then I suspect that these affidavits that were submitted are lies, and that he has been lying. And I want to reaffirm the lies in the courtroom. I would like him to answer these questions. And if he doesn't answer them, it's because he's now uncomfortable, like Jim Carrey in the movie Liar, Liar.
Yeah.
I would like him to answer these questions. If he doesn't answer them, then it means that they're lies. And I would like to...
Well, see, but I understand what you're saying, but I see that as kind of cross-examination that's going to be done by my attorney on him. I mean, I kind of see that what you're saying is something that's going to happen in court. I mean, isn't that cross-examination what you're basically outlining?
Yes, Gary. What I'm saying is you need to reaffirm the crap that he has submitted. Take the crap that he has submitted under the impression that he's going to act like Jim Carrey in the movie Liar, Liar. And now re-ask him these questions and make sure that he reiterates it and tell the judge the reason why I'm asking them is because I don't think anybody can lie under oath anymore in my cases. And I would like to reaffirm the crap he's submitted. And if he doesn't answer the questions, it's because, like the movie Liar, Liar, he is avoiding the question because he cannot lie anymore. And I would like to use that as testimony, as indication that he cannot lie. In other words, if he doesn't answer my question, that means that he's lying. He's lied in these other answers. And I'd like to use that as evidence to say, in my summary judgment, that I would like to win. I would like to win my case because it's been bogus testimony submitted previous to this current testimony. See?
Yeah.
And
You there?
yes, I'm just trying to make sure you understand how to make him cough it up. Again, now that he's now locked under oath and he cannot submit any more lies, make him cough it up and make everybody watch. Make the jury, make the judge watch him. And then you say, listen, the reason why he's not answering the question is because it would be a lie, because he can't lie anymore.
Well, I don't know how, in Minnesota, in Arizona, when you put in an affidavit, you do swear to that. And then you have it notarized. It's just not a blanket statement. You know, you just put it in. It's a notarized, sworn to statement.
Gary,
you're saying that's true.
Gary, under my cases, the oath is different. Nobody can lie. That's why I'm trying to contract with you. That's what I'm selling my service to you, that no one can lie under oath, that people will act like Jim Carrey in the movie Liar, Liar, once you contract with me. Now you use those bogus statements previously submitted, that yes, he submitted an affidavit under oath. That was bogus because you weren't dealing with Chris Roller, but now that you are, you now have a new weapon in front of you now. And now you just need to make him act like Jim Carrey in the movie Liar, Liar. Do you understand? Previous stuff.
No, well, I do understand, but what I don't understand is, like, okay, you have some secret, maybe that you're not divulging to me, you know, but I don't see what you're saying, how it's going to be much different from cross-examination anyway. Because, like what you just said, that's going to happen. I mean, the day of reckoning of him, looking at his emails, and also my attorney saying to him on the stand, you wrote this affidavit on such and such a date, but yet you wrote and sent this email on such and such a date authorizing such work. So, are you now saying in this affidavit that you didn't authorize it? I mean, that's kind of how I see cross-examination going down. I mean, nobody knows what he's going to say, because we all know he's in a tough spot once it gets to that point.
Gary, I just keep repeating myself. I'm trying to get you to understand the power of this. Think of the movie Liar Liar. Think of that power. I can't explain it in any other form. You still don't understand what I'm talking about. I'm saying that he cannot lie anymore, like the movie Liar Liar, but it's reality now. In my cases, people have a hard time answering my questions. In fact, I'm not getting questions answered because they cannot lie anymore. They would like to tell me these things aren't happening, but they cannot. So all you have to do is, I just keep repeating myself. I don't know how to explain it to you. You keep coming up with, just think of it.
But the way you're describing it to me, I see it as what's going to happen. Not the Jim Carrey part, but I see him being in a tough spot in your description when it comes to that point anyway. I mean, unless, you do have some secret way of making him not being able to talk.
Yes, it is a secret way. Yes, it is secret. But let's just assume that it's true. Stop assuming.
Okay.
Stop wondering how it works, and just imagine that it works.
Okay.
I mean, you're an engineer, right? Are you an engineer?
No, my brother's the engineer. I work more in the quality control department. So I'm a QC person, quality control.
I understand. So, I guess I can let you go here, but just think of it like the movie Liar Liar. Now imagine you had that power. Imagine it was true. What would you do? What would you do? What would you and your lawyer do to re-examine the evidence that's been submitted? And I guess...
Oh, I get a lot before in the courtroom. Like I said earlier, making him reconcile conflicting statements of his own and evidence, conflicting evidence of his own. That's what we would do.
Listen, I got another call coming in. I can't. I don't know what else I could say that you could better understand what's going on. You have to assume that this is true.
Okay.
What's happening? That Liar Liar is true now. Now imagine.
Okay.
Now just start thinking about what you would do. You and your lawyer would do to take the current trap and then convince the judge that because he can't say it again, that means that it was a lie before. And I'll just leave you with that because I can't explain it any better than that.
Okay.
Okay, Gary. So I'll talk to you in a few days then and see what you think.
Okay. You have a good weekend.
You too, sir.
Thank you.
Bye.
Bye-bye.